Hey, test 1 2 1 2 1 2. You don't have any? One two 1 2. Test 1 2. You got nothing, huh? Test 1 2 1 2. 1 2.
Subcommittee will come to order. My apologies for being late to both of you and to the committee staff and to my ranking member. We are in the throes of trying to do something for the economic benefit for people, given the public health emergency crisis we have with coronavirus. So, good morning to you, Chairman Ring and General Counsel Rob. We welcome you to the subcommittee and thank you for joining us to testify this morning. I might add this is the first hearing on the National Labor Relations Board in 5 years. And today what we are doing is examining the NLRB's budget request for 2021, a proposed 10% cut of $27 million. To start, let me just say that after years of flat funding, it's my sincere belief that the NLRB needs more resources and not cuts. Although this is a budget hearing, it is also our duty to conduct oversight of the resources this subcommittee provides to your agency. And I, in full disclosure, have serious concerns that I will address today. 2020 marks the 85th anniversary of the National Labor Relations Act, a landmark law that has secured freedom of workers to represent themselves in the workplace. And the Congress designated the National Labor Relations Board to defend it. The NLRB's role is to ensure that workers can form or join a union, be represented by that union in collective bargaining, and be free from retaliation from doing so. These are basic rights. Sadly, I believe that the administration has been undermining protections, unions, and workers. And the Nlrb has taken every opportunity to dismantle workers' rights to organize. And let me recount some of what I believe are the board's most egregious rulings and regulatory efforts that seek to deny labor protections for thousands of workers, including the Super Shuttle decision, where the board permitted its employees to be misclassified as independent contractors on the grounds of, quote, entrepreneurial opportunity, despite the fact that these drivers had non-compete clauses, totally undermining any entrepreneurial opportunity. This is about, in my view, denying benefits. The proposed graduate student rulemaking, where the board seeks to strip students of their protections under the NLRA when they perform work for the university. Between 2005 and 2015, the number of graduate teaching assistants grew by 17%, whereas tenure-track faculty grew by only 5%. The increased reliance on student workers is clear, as is the NLRA, which does not include students in its statutory exclusions. The board's new joint employer rule, which makes it easier for unscrupulous companies to sidestep their legal responsibility to bargain with their employees by hiding behind contractors and subcontractors. And I have to ask, do you believe the NLRB is an advocate for corporate interests? I will quote from Help Committee Chairman Lamar Alexander, who implored the Trump board nominees to, quote, this is a quote, restore the labor board to the role of a neutral umpire in labor disputes after years of the board acting more like an advocate. And I think it's important in this respect to quote Section 1 of the National Labor Relations Act, which says that it is the policy of the United States to encourage the practice and procedure of collective bargaining and to protect workers' rights to unionize for the purpose of collective bargaining. That is what the agency's requirement is. We've had 6 major rulemaking procedures, 20 reversals of significant precedent. There should be on both sides of the aisle an outrage at what an advocate for corporations that the what I view as anti-worker board has become. Mr. Ring, Mr. Robb, I also have to address the alarming ethics and what I view as mismanagement issues happening under your leadership. 2017, the board, including board member William Emanuel, overruled precedent established in the Browning-Ferris decision on joint employment. This was a major victory for business and corporations looking to shirk their labor law obligations. Mr. Emanuel participated in that decision even though his former law firm represented a party in Browning-Ferris. Ultimately, the board's designated agency ethics official concluded that Mr. Emanuel had a conflict of interest and should have recused himself from the case. Mr. Ring, last year I expressed serious concern to you about the procedures that were in place for board members to ensure case decisions and rulemakings are compliant with all ethics standards. You assured me that you are hard at work to restore our confidence. But sadly, your November 2019 ethics recusal report falls far short. Instead of showing that your board has learned from prior mistakes and intends to do better in the future, you declared that a member like Mr. Emanuel can, quote, insist on participating in a case even when the agency ethics official finds a clear conflict of interest. Meanwhile, you would have the Office of Government Ethics adjudicate whenever the member disagrees with the ethics official, but they have subsequently asked you to revise the report to to clarify that members do not have a right to appeal their disagreement to OGE. The director of the Office of Government Ethics rebuked your report, and he wrote, and I quote, "I am very concerned that portions of the report characterize ethics requirements and processes in ways that could be misconstrued." Mr. Robb, another area of concern is the agency's mismanagement of federal funds and its hollowing out of the regional offices. Under your watch, the NLRB let $3 million expire in 2018 and $5.7 million expire in 2019, 2.1% of the agency's total appropriation. Meanwhile, since fiscal year 2016, your staff have declined by 17%. Multiple regional director positions remain unfilled. Mr. Robb, you are really frittering away resources that Congress provided for you to enforce the National Labor Relations Act, and this committee would like to get to the bottom of it. At its best, in my view, it is mismanagement, which we have condemned, and I might add, on a bipartisan basis. At its worst, it is a disregard of congressional and constitutional authority. And the result is that working people are hurt. Their rights, their protections are undermined. We have seen regional offices understaffed. It makes it harder for workers to secure protection of their collective bargaining rights when they file unfair labor practice charges. I was grateful to work with Ranking Member Cole and my Senate colleagues in the bipartisan fiscal year 2020 Labor HHS bill to include language that addresses significant underspending on personnel costs by directing the board to expand the number of regional staff beyond the amount that were on board at the end of fiscal year 19. We intend to learn how your agency is planning to comply with this directive. And I might add, and as you know, I have joined with Senator Patty Murray to ask that the Government Accountability Office look into this troubling issue. Deliberate underspending on personnel costs and mismanagement of the board's annual appropriation will be taken very seriously as we draft the fiscal year 2021 appropriations bill. It appears that the NLRB has become hostile to the well-being and satisfaction of its own workers. In fact, NLRB staff report some of the highest levels of disaffection in the federal government. So the change needs to happen there and everywhere. Attacks on workers' rights are not serious attempts to restore jobs or to boost economic growth. Instead, they are designed purely and simply to accelerate a race to the bottom. They can only do further harm to middle-class families who struggle every day to make ends meet. We thank you for being here. I look forward to a robust discussion to get to the bottom of these issues. And now I would like to yield to Ranking Member Cole for any opening remarks that he would like to make.
Thank you, Madam Chair. And just housekeeping first, if I may, I just want to advise you I'll probably have to leave early for a hearing, defense appropriations. So thank you again for convening this hearing. Good morning. It's wonderful, gentlemen, to have you, Mr. Ring, and Mr. Robb, both of you here, and I want to thank you for coming. I look forward to discussing the NLRB's fiscal year 2021 budget and other policy issues with you today. The NLRB has long been characterized as a partisan and political institution when it comes to issuing decisions. Yet in recent years, over 80% of case decisions have been issued unanimously. And in some cases, like the Joint Employer Standard, the board is returning to long-standing precedent from numerous administrations, and I certainly commend you for that. The Joint Employer Standard under the NLRA is a matter of consequence because it determines whether a business is an employer of employees directly employed by another employer altogether. Under the prior decision, if two entities were joint employers, both would have to bargain with the union that represents the jointly employed employees, and both would have been potentially liable for unfair labor practices committed by the other. Both would have been subject to union picketing or other economic pressure if there were a labor dispute. Frankly, in my view, the franchise model has been the basis for many successful small businesses. Small businesses are the job creation engine of our economy, and in many cases, subcontractors are an integral part of this model. And quite frankly, in many minority communities, they're the most significant business owners in the districts, and this has been a ladder of upward mobility, I think, for our population. So I support the board's recent decision on this matter. I think it was the right one, and I commend you for it. Finally, I want to raise another matter of personal importance to me. The National Labor Relations Act of 1935 recognized the right of employees to organize labor unions in private industry. All governments were excluded from the Act's definition of an employer. No government is covered by the Act. For decades, the Nlrb recognized Indian tribes' exemptions from the NLRA's jurisdiction as they are sovereign governments. Incomprehensible to me why in 2004 the board asserted jurisdiction over Indian tribes after so much history and precedent. However, the House actually has twice passed legislation, bipartisan legislation I might add, to remedy that overreach. A majority of the United States Senate actually supported that. We just couldn't get to cloture. We literally had 58 senators. So I think hopefully over time you'll recognize there's significant legislative support for looking at this decision, which I think was an egregious bureaucratic overreach, obviously long before either of you were on the board. And I would hope that over time can be reversed. Finally, while I share some concerns on the budget, I want you to know I appreciate you being careful stewards of budgetary matters. We've got extraordinary demands on this committee. It's unusual when we see folks come and actually say maybe we can do the same job with less money. So it's welcome because, believe me, there's many demands on the resources that this committee has allocated. So being able to direct some of them elsewhere is often very, very welcome thing, and frankly, something we don't see very much. So I look forward to discussion this morning, and I yield back my time, Madam Chair.
Thank you. And Mr. Ring, Mr. Robb, we are happy to place your full testimony into the record, but you'll each be recognized for 5 minutes to summarize your statement, and then we will proceed to questions. And there are 5-minute rounds for questions. So with that, Mr. Ring.
Chairwoman DeLauro, Ranking Member Cole, and members of the subcommittee, I'm pleased to be here today to provide you with an update on the work at the National Labor Relations Board. I'm happy to report that the board has worked efficiently and effectively to carry out the important mission of the National Labor Relations Act. On July 5th of this year, the National Labor Relations Act will turn 85, as the chairwoman had mentioned. Like our predecessors who served on the board over those nearly 85 years, the current board members take very seriously our responsibility to fairly and impartially enforce the Act. General Counsel Robb will update you on the side of the agency he oversees, which includes our regional offices. I'd like to focus on the successes on the board side of the agency, which includes the members, their staffs, the offices that support the board's work. On the board side, we have 148 employees, full-time equivalents, and the board's funding allocation represents approximately 11.5% of the overall agency's budget. The board's primary area of focus over the past fiscal year has been our case processing effort. The board instituted a pilot program to focus on enhanced oversight of case management and case status transparency. We paid particular attention to issuing decisions in some of our oldest pending cases. After only a year of this effort, I'm pleased that our overall case processing statistics for fiscal 19 reflect positive results. The board issued 303 decisions in contested cases in fiscal 2019. We reduced the median age of all cases pending by almost 33% and significantly reduced the number of cases pending by almost 20% to its lowest level since 2012. These statistics are strong evidence that our efforts to reduce the case backlog and ensure timely decisions for the parties are bearing fruit. Seeking to build on these successes, the board intends to focus its attention on eliminating our oldest cases by the end of fiscal 20. We know that the purposes of the Act are not served by making parties or the American workers wait years, and in some cases up to 10 years for cases to issue. Another area of emphasis by the board over the last year has been our rulemaking. Although the Nlrb historically has made most of its policy through adjudication, the current board believes that there are significant advantages to rulemaking. Rulemaking allows the board to provide far more comprehensive and detailed guidance to our stakeholders than adjudication. Rulemaking also offers the opportunity for substantial input from the public, and not just those who can afford a lawyer to write a brief. We've had significant public participation in our rulemaking efforts to date, and the board has found the input valuable. I'm pleased that we've issued as was mentioned, our final rule covering joint employer standard under the Act. Although the rule took us almost a year to complete, we considered nearly 29,000 comments, and those comments allowed us to craft a very well-informed rule. The rule restores, as was mentioned, the joint employer standard. The board applied for decades prior to 2015, and it does so with the greater precision, clarity, and detail that rulemaking allows. We're also engaged in rulemaking regarding the board's current standards for blocking charges, voluntary recognition, the formation of 9A bargaining relationships in the construction industry, and we also have ongoing rulemaking regarding standards for determining whether students who perform services at private colleges or universities in connection with their studies are employees within the definition of the Act. The board issued a final rule amending the agency's representation case procedures, retaining some of the essential elements of the agency's existing representation rules. Our final rule modified only selected sections to create what we believe is a fairer and more efficient election process. Finally, I am pleased to report that the board completed a comprehensive 18-month review of our agency's ethics and recusal procedures. The board found that the review found that the board's practices for identifying conflicts, establishing screening arrangements, and obtaining our designated agency ethics officials' input on recusal matters are very strong, fully compliant with applicable government ethics rules, and will protect against conflicts of interest. Based on this review, the board also identified certain areas for improvement, the most important of which I have summarized in my written testimony. I thank you for the opportunity to appear before you today to provide this update, and I look forward to your questions.
Thank you very much. Mr. Robb.
Thank you. Chairwoman DeLauro, Ranking Member Cole, and members of the subcommittee, I am pleased to testify before you today. As General Counsel, I have a dual role in directing the litigation of cases under the Act at the Administrative, Board, Federal District Court, Circuit Court, and Supreme Court levels, as well as overseeing the operations of approximately 90% of the agency. The General Counsel is also responsible for overseeing the investigation of unfair labor practice charges, processing representation petitions, enforcing board's orders, and supervising the operations of Nlrb regional and satellite offices, as well as headquarters staff, who are responsible for case handling, operational, administrative, financial, security, facilities, technology, and personnel functions. The prompt resolution of labor disputes is essential to enforcing the Act and a key part of the agency's mission. Expeditious case processing by the agency is necessary to achieve the timely resolution of labor disputes, thereby helping to minimize interference with the free flow of commerce. Over many decades, agency case processing times and case backlogs have increased, causing delayed resolutions of disputes. In the 1980s, the median processing time from the filing of an unfair labor practice charge to the issuance of a merit complaint was between 44 and 55 days. By the end of fiscal year 2018, the median processing time had risen to 128 days. Backlogs in the number of overage, unresolved unfair labor practice cases also grew. For example, at the end of fiscal year 2012, there were 524 pending overage cases. By the end of fiscal year 2018, there were 724 pending overage cases, a 38% increase in case backlog. These lengthened case processing times and backlogs surprisingly occurred during a period in which unfair labor practice case intake dropped from 21,622 to 18,866 cases, nearly a 13% decrease. My major objectives as General Counsel are to reverse this trend, to ensure the processing of cases in a timely manner, to improve our service to the public while maintaining the quality of investigations and litigation. To that end, at the beginning of fiscal year 2019, the agency issued a strategic plan which established case processing objectives for the disposition of unfair labor practice charges at all levels. The goal was to reduce case processing time by 20% over the next 4 years. During fiscal year 19, the regional offices made exceptional strides toward meeting that goal. In just 1 year, the regions nearly met our 4-year goal by reducing the overall average time of filing to disposition of unfair labor practice cases from 90 to 74 days, a decrease of 17.5%. Regions also reduced the time from informal settlement to final disposition of an unfair labor practice case, which affects how quickly alleged violations are remedied, from 173 to 153 days, a decrease of 11.5%. These results were achieved without any detriment to the quality of case processing, the number of cases the field office decided to prosecute, or the amounts recovered by the agency on behalf of wronged employees. Over the past 2 decades, the percentage of charges that have been found to have merit have hovered between 35% and 37%, and fiscal year 19 was no different. The percentage of merit cases was 36.1%. Additionally, since fiscal year 2012, the median amount collected annually for employees has been approximately $55.2 million. In fiscal year 2019, the agency collected over $58.4 million, well above the median. Not surprisingly, given the expeditious handling of unfair labor practice cases, the regional office's settlement rate was 99%. Finally, the divisions of Operations Management, Advice, and Appeals, which review the quality of field work, have confirmed that the quality of the work performed remains high. The Nlrb plays a crucial role in ensuring that workplace disputes are resolved efficiently and effectively. I assure you that the agency will continue working to ensure that labor disputes between or among workers, employers, and labor unions are resolved effectively and efficiently, as we have done for the past 85 years. Madam Chairwoman, thank you for allowing me this opportunity to explain publicly to the committee the achievements of this past year and to congratulate all Nlrb employees on a job well done. Thank you.
Thank you. Thank you both for your testimony. We proceed to questions. And Mr. Ring, as I pointed out, I'm concerned about the ethic issues that have been plaguing the Nlrb. Again, Mr. Emanuel participated in the 2017 Highbrand decision, which overturned Browning Ferris. He participated even though his former law firm, Littler Mendelson, and I might add about Littler Mendelson, this self-described, which defends corporations by taking on workers' rights to unionize. He participated even though he was, that was his former law firm, represented one of the companies in Browning Ferris. The designated agency ethics official understandably concluded that Mr. Emanuel committed an ethics violation because he had a conflict of interest. Your board's commitment to upholding basic ethics standards was already in question, and again, sadly, your November 2019 ethics recusal report raises more concern than it eases. You somehow conclude that a member like Mr. Emanuel has no obligation to enforce an ethics official's finding and recuse himself when a clear conflict exists. Mr. Ring, do you believe Mr. Emanuel, former Littler Mendelson shareholder, had a conflict of interest when he overturned Browning Ferris? And in the interest of time, because I only have 5 minutes to get on, yes or no?
It's not a yes or no answer, and let me tell you why, if I might. He wasn't overturning Browning Ferris. The case was a different case.
But let me just say, your ethics people concluded that it was a conflict of interest. Is it? We just ignore what the ethics committee said? Is that what you did? You just ignored what the ethics committee said about conflict of interest.
No. Well, let me say, if I might, what the unfortunate facts of the situation you're describing is that the ethics official concluded that he had violated the ethics rules
Yes.
after the fact. It was after the fact because of the way the case was decided. This all happened before I was chair, before I arrived there.
I understand, and I'm not but just saying it was a complete violation, a finding that there was a violation. So I'm taking this as he was in violation. There is no explanation for flying in the face of the ethics board saying conflict of interest. Your September 18th proposed joint employer rule effectively established the same joint employment test included in Highbrand. And if Mr. Emanuel committed a conflict of interest in Highbrand, how is his participation in the rulemaking not another egregious conflict?
Well, the standard for ethics, as explained to us by our designated ethics official at the agency, is different than for adjudication of cases. In adjudication of cases, you look at the particular matter and whether there's specific parties. In rulemaking, there are no specific parties, so the standard is different. And I will just add that the ethics officer has approved his participation in the rulemaking.
Well, let's talk about rulemaking for a second. Chairman of the Nlrb for less than 2 years, initiated 4 rulemaking efforts. You are currently working on 2 more, 6 rules, unprecedented. Proactively using rulemaking as a tool to advance, what in my view, and I said my view, an anti-worker agenda. Obama-controlled board published 2. The Bush-controlled board published none. Instead of holding public hearings like the previous board did with its election rule, you conduct all 6 rulemakings behind closed doors. This contributes to the appearance that you have little interest in transparency. We should be concerned in light of serious conflicts of interest, what's happening behind closed doors. Mr. Emanuel participated in the joint employer rule despite committing an ethics violation in Highbrand earlier on. I will just conclude my round by saying, I just, under your leadership, the board is a classic case of the fox guarding the henhouse, where a group of conflicted individuals are rewriting the rules of the road to benefit the industries where they have a financial interest or have had a financial interest. It's wrong. We cannot do that. We live by, if you want to tell me that this is perception is reality. Optics are real here of conflict of interest, which appears to run rampant in this agency.
Thank you very much, Madam Chair. Chairman Ring, your case processing, as you pointed out in your testimony, has really gone down in recent years. Under a pilot program, the board began to focus on issuing decisions in your oldest cases. As a result, the median age of all cases pending before the board was reduced from 233 days to 157 days, more than 30% reduction. In addition, as you pointed out, I think, Mr. Robb, in your testimony as well, the board significantly reduced the number of cases pending to its lowest level since 2012, a nearly 20% reduction. I think that's very commendable. And I just want to ask you, number one, how you achieved it, and number two, how do those efforts, frankly, help both employers and employees across the country?
I'll be happy to start. One of the, I think as long as I say in my written testimony, as long as there's been a board, there's been complaints about how long it takes to get a decision out of the board. As a practitioner before the board, I have waited for many years to get decisions out of the board. And during that period of time, people, workplaces are in limbo. I think of individuals who have stood up to their employers and have been told you'll get your job back, and then have to wait 3 and 4, up to 10 years to get their job back. So really, justice delayed is justice denied when it comes to the board. So that's one of the ways that I think that we really need to advance the mission of the act is to as quickly as possible and effectively resolve our cases. I did a lot of reading about a lot of studies. There's been GAO studies and a lot of law review articles about case processing at the board. The reality is, what it all comes down to is commitment by board members to actually focus, give full attention to their obligation to decide cases. So we have, as a board, and including our former member McFerrin, committed ourselves to full attention to deciding cases and processing cases. And we meet, and this is unprecedented, as a board, and we look at the status of every single case, and we hold ourselves accountable to that. This is not about staff delaying. This is not. It's all within the targets that the staff we already had. It's really about board members being committed to moving the cases, and more transparency and a little bit of internal competition among board members to make sure you get the cases decided. So that's been our approach.
You care to add an additional comment, Mr. Roth?
Sure. In 2018, in the fall, when we looked at trying to improve our case processing on the GC side, I had a conference with all my regional directors, and there had been some suggestions made by people in the field as to how we could speed things up. And when we talked about it, I asked the directors how we could get this done, and they said, look, don't dictate from on high, let us handle it, and we can work it out individually in the regional offices. I said, fine, go ahead and do that. And as you can tell from the results, they did a tremendous job. But I want to emphasize that all of this work is done by our field attorneys and field examiners who do the investigations and process the R cases. So they're the ones that deserve the credit for this.
Just quickly, because I don't have a lot of time left, Chairman Ring, obviously we're going to be talking a lot about rulemaking this morning, I'm sure, and you've overturned a number of previous decisions. You just sort of tell us your philosophy as you approach these, how you look at it. Just quite frankly, I agree with most of the decisions you've made. So I see you as returning to traditional practice in the board and overturning some overreach from the last administration. But I'm curious how you approach these matters.
Well, I think rulemaking makes a lot of sense for a lot of reasons. It allows us to deal with complex areas of law in a more comprehensive way. It allows us to give better detailed descriptions of and guidance to our stakeholders. Allows public input. I would do more rulemaking if we could. We are building that capacity out at the agency, and so we have to kind of balance between adjudication and rulemaking, and with our focus on deciding cases, and making sure that we have a real focus on that. I don't want to distract from that with the rulemaking. So it's been a balance, but that's been our approach.
I'm out of time, so I look forward to continuing the discussion. Thank you, Madam Chair.
Congressman Pocan.
Yeah, thank you, Madam Chairman, and thank you both for being here. I do just want to say I associate myself with the concerns of our chairwoman on the perception issue. S.I. Hayakawa, perception is reality. The problem is if you have a board member who doesn't know better that they're obviously doing an ethics violation, and then something so related they act, is just bad judgment, period. And I think you have to get a better control over that. Otherwise, the perception looks like this is a rigged board. Your last non-answer, unfortunately, to Mr. Cole, you didn't describe your philosophy. You said rulemaking is good. I want to do more rulemaking because I like rulemaking. That's not a philosophy that you're using to set standards. I understand lawyers give answers in certain ways, but I think it's a problem when you have like a guide by the U.S. Chamber of Commerce that has 10 recommendations for your agency, and every one of them you hit. You got 100%, but I don't know if that's necessarily good for your mission, which is to also make sure that workers feel like they're represented by the agency, not just employers. And this is as a 30-plus year employer. I'm saying that because I just think that perception makes you less credible and less able to do your jobs. So I just want to put that out there. To that end, I do have some questions around, you mentioned all this efficiency you're doing. Actually, the perception and the reality in the ground is just the opposite, and I think you need to hear this, and I'm sure you are. But when you made some of your new rules around union elections, for example, you mandated longer time. You went through all, well, actually, let me go to this one first. I'm going to do, on the efficiencies within the regional offices, let me go to that first. You have not filled a bunch of spots. While you're claiming you're getting rid of some of the backlog, you've had memos changing the performance of how regional directors will be evaluated. You're discouraging the use of subpoenas and investigations. You're reducing staff and leaving positions vacant. I have folks telling me that they aren't even bothering to do claims anymore because they don't feel like they're getting heard. So I guess the question is, while you may be taking care of some old cases, what we're hearing is people aren't even filing cases because they don't feel like they're even be given a chance because you're short-staffed in some areas and you're not allowing the normal practices that happen. Can you just briefly, because I have a limited amount of time, respond to that?
So this is actually a General Counsel Rob question because he runs the regions.
Sure.
But, yeah.
Thank you.
Certainly. With respect to whether charges are being properly investigated, all our reviews indicate that they are. As I said before, the merit factor is exactly the same as it was with my predecessor.
So let me-
there's no factual reason for anyone to believe that we're not going to find.
Well, let me try this fact, Mr. Robb, see if this helps. Not only do you have many unfilled vacancies, but your regional offices are issuing 27% fewer unfair labor practice complaints than they were just 2 years ago. So people feel that it's many of those changes is why you're not going after these cases, and it's not like, I think, and I can say this again as an employer who's involved in many chambers of commerces, we're not suddenly good actors. Nothing has changed on our end, but you certainly are going after fewer people, and there are bad actors. I think we all agree out there. How can you know, when people see that statistic, that's not a good statistic.
Well, the statistic that you cited was issuing complaints. That we resolved more cases by settlement prior to complaint issuance. 800, I think it's around 6,000 of them last year. So that's where the difference is. It's not that the violations are not being
And that's where I disagree, because what I'm being told, people aren't filing the complaint. So if that's you may think that's a perception, but the perception is the reality if people aren't even putting complaints in because they feel like the system is rigged against them. So let me go to where I started on the question on the election rules. Again, you made some rule changes. Even when your members on your board said that the average election now will go from 23 days to 78 days later. So your own members on the board said that. And yet you did this without any public comment whatsoever because you said these were common sense. I don't find that to be common sense if you don't go out and get any public comment. Can you explain very briefly why you didn't get public comment?
Sure. These are procedural rules, and the board historically has handled their representation rules by final rules. I mean, that they've issued them with final rule without any rulemaking. In 2014, where there was a wholesale change to the rules, including rules that affected rights of individuals, and we were very careful in this rulemaking not to do that. They did go out in 2014 for
So again, the
public comment.
perception is that you guys are operating differently and not asking for public input, which is making your agency less efficient. The last thing, if I can really quickly, Madam Chair, is just trying to understand on a ruling you had in January of 2019 where you expanded the definition of independent contractor in the super shuttle case to these people who are driving the shuttles, and yet at the same time they're independent contractors. They're supposed to sign non-compete agreements, which again I think is absolutely idiotic. What is the inside information to driving a shuttle? And yet that was the ruling you had. Can you explain that? That makes no sense to me as an employer or as a lawmaker.
Yeah. Well, the super shuttle decision restored the independent contractor test to what it had been for decades. That was the standard for decades. It had been expanded during the Obama board years, and we restored it to the prior standard.
So you didn't answer my question, so let me try again. I'm sorry if I wasn't clear. Again, I'm just trying to understand, just because something was, you're not telling me why it should be. an independent contractor, but if it is, then if it should be an independent contractor, why are they forced to sign a non-compete agreement as a shuttle driver?
Yeah, I can't speak to the independent, to the non-compete aspect. We did look very carefully at that case. We looked at all the facts, considered all the arguments. Ultimately, the decision was, I think, in our analysis of the case is laid out in the decision. We think that the common law standard for independent contractors is what the standard should be.
I thank the chair for her extra time. Thank you.
Congresswoman Clark.
Thank you, Madam Chairwoman, and thank you both for being here today. Just to pick up on my colleague's line of questionings, in this super shuttle ruling that the drivers should not be classified as employees, but actually as contractors, the board ruled that it is entrepreneurial opportunity that is at the core of the test. How is it true that an indicator of entrepreneurial opportunity test, which is one's ability to work for another company, how does that possibly square with a non-compete clause for these drivers?
I mean, I'll just speculate, but I will say, I mean, there are many businesses where you hire a contractor, a subcontractor, and you say, you will only work for me, or you won't work for other businesses. I mean, if you have that, if you have that economic control, you can do that. What we were talking about with entrepreneurial control there was what the D.C. Circuit had talked about, and that really is the animating feature of the independent contractor test, in our view.
I just don't see any way how those two work together. If we are talking about entrepreneurial opportunities, I agree with you. We look at non-compete and businesses have right to do it, but it's hard to say they're independent contractors when they are being told they cannot compete, cannot seek entrepreneurial opportunities. I think that your former board member, Lauren McFerrin, got it right when she said that this approach might be easily called the economic unrealities test. I don't know how you square those two things, and I'm concerned about the direction that you're taking, which brings me to my next line of questioning and some of the rulemaking that you're doing. One of them is a proposed rule in December that classifies graduate student workers as students and would strip away their right to collectively bargain and join a union with better wages and better working conditions. Isn't the role of the Nlrb to safeguard employees' rights to organize and form a union if they so choose? Isn't that your mission?
It's one of the objectives of the Act, overarching objective of the Act is labor management stability, and to make sure that there's not labor strife. Look, the student rule is a rule that and that issue is an issue that the board has flip-flopped on many times. I think it's 3 or 4 times in the last 20 years. Each time the board looks at it, it's in a context of a particular set of students in a particular university under a certain set of facts. In our view, rulemaking is the perfect way, a perfect vehicle to take that complex issue and look at it in a really comprehensive way.
Well, what you describe as flip-flopping actually affects 1.5 million student workers. If you just take Harvard, which has been looking at this issue in my district, the average salary for student graduate workers nationwide was just under $14,000. For professors, it was $121,000. But those student graduate workers are grading papers, holding classes, holding office hours, all the same functions, and yet now you're saying they're not workers at all. but they're students. And I don't understand how you are coming up with this new rule and why you wouldn't be securing the rights to organize for these 1.5 million workers. You have said at one point this is over a concern of academic freedom. Can you explain to me what you meant by that?
Well, I think where you start imposing collective bargaining or collective bargaining obligations that could impact the ability of a whole host of things, scheduling of classes, what courses are taught, and that could impact economic freedom.
I don't understand the connection between allowing workers who are doing the exact same work on many times, except that they, as professors, except they are also going to classes themselves, how that in any way impinges on anyone's academic freedom to allow them to organize to have better working conditions and fair wages. I just don't even see the connection.
Well, this is part of the reasons that rulemaking makes sense, because we can look at these comments and input like that, and then make a judgment. Our proposed rule was a proposal that is subject to comment, and we're open-minded about changes to the rule.
I see that my time has expired. I certainly hope that you will not go forward with this rule and respect these workers' rights. Thank you.
Thank
you. If I might, in a couple of pieces, I just want to a point that my colleague from Massachusetts made, which I said in my opening remarks. 2005 to 2015, the number of graduate teaching assistants grew by 17%. Tenure-track faculty grew by 5%. As she has pointed out, what these I work with the graduate students. They are dealing with classes. They are grading papers. They are doing the same kind of work. And NLRA does not include students in its statutory exclusions. Why we would strip these folks of their ability to be able to organize is something that is not comprehensible. On the super shuttle, I might add, by the way, including that, and I'm not going to get into personalities, but my understanding is that a board member who worked on this issue also had a family that worked for Columbia University, and the individual on the board participated in the graduate worker rule. You got all kinds of conflict of interest running here, there, and everywhere, and not, paying attention to what the stated purpose of the agency mission is to allow collective bargaining rights and workers to be able to organize. Super shuttle on the non-compete clause, as I understand it, Mr. Chairman, that you discounted the fact in the decision there was no analysis of the non-compete clauses. Do we put a non-compete clause on a plumber? No, we don't. And about your issue on rulemaking, it sounds good, but rulemaking is behind closed doors. There are no public hearings, and that is, want to be transparent? Let's be transparent, and let it fall where it may with the decisions that are in the best interest of those that you are supposed to represent, and that's the workers. Mr. Robb, 2 consecutive fiscal years, you let resources provided by the board lapse. $3 million in 2018, $5.7 million in 2019. Under your watch, NLRB staff levels have dropped by alarming rates. Government-wide analysis of staffing levels under the Trump administration from 2016 to 2018 shows that the NLRB suffered reductions of 14%, the most significant reduction for any non-cabinet agency with at least 1,000 employees. End of 2019, that reduction grew to an astounding 17%. You have the responsibility to use the funding this subcommittee provides. We did this in a bipartisan way. 2020, The Labor H Bill directs you to expand regional staff. You've talked about giving more authority to regional staff, and there where you're looking at you have 33 fewer staff in the regions than you did at the end of 2019. So yeah, they're moving cases, and they're doing it with a lot of short staff. It's not about quantity, it is about quality that we are talking about today. So my question is, will you comply with the directive and ensure the NLRB has more regional staff on board than it had at the end of 2019, and how are you planning on complying?
The last time that I had a report on our staffing situation for the field, we had 815 field staff. The number at the end of, that's FTEs, the number at the end of fiscal year 2019 that you're referring to was 830. We have 16 people currently that are in the hiring process. We're just waiting for them to be able to come on board. So we're on track to have the same or more field employees as we did at the end of fiscal year 2019, which was the directive in the report. I will note, though, that we've had a 5% decline in caseload. 5%. That means that there'll be a lot less work for people to do if we have the same number of people.
You know, I was the chief of staff for Senator Dodd for a number of years. And we had a copy machine that the whole staff said to me, it's non-usable, we can't get copies, etc. So I went to our office manager and I said, you know, we need a new copy machine. That's what the staff is telling me. And she said, if we get a new copy machine, more people will use it. Whoa, okay. Why is it there? Why do you have regional staff? Why are we understaffing them? Yes, the caseload will drop. Why? You don't have staff there to do the various investigation, the analysis, to go through each and every one of these cases. You're dealing with, was my colleague talked about, you issued a memorandum discovering regional directors from issuing subpoenas when investigating whether to issue a complaint. Last year, there were 64% fewer cases. So you're in the mode of, if you pull back and not provide the staff, if they don't have the tools of the trade to be able to deal with this effort, then we'll have fewer cases because they can't do with them. It really is. Look, I just want to say to you that Congress expects you to implement these bipartisan directives. Fill vacant regional director positions expeditiously. What you did was you went in St. Louis, as I understand it, conducting a search for the St. Louis regional director position. You concluded you could not find a qualified candidate. You know, that's a charge that's often made when you are, not wanting to find that director. And I have to apologize to my colleague from Florida because when she wasn't here, I was up next, but then she is here now. So let me.
I'm sorry, I've been running back and forth to two meetings. Thank you, folks, for being here. I wanted to just follow up on your last round of questions, just to, in terms of your cutting your agency, the budget. Is it true, I don't know if this is true, it's hard to believe, so hopefully I'm wrong, that in 2018 you ended the contracts with the health units, which were the on-site health clinics that served the NLRB, and you cited budgetary constraints. Did that happen?
I was not at the agency then, I'm happy to say.
Did that happen, sir?
Yes, it did.
All right, well, it's, okay. Well, going back to the questions of my esteemed chairman, it seems to me that you didn't really have budgetary constraints. It is, again, this is what I read, so it's really hard to believe, but it says that the most recent cost of the program was $331,000 per year. Well, your agency's been under investigation for the GAO for failing to spend the funds, our funds that we allocated. And let's see, you returned $5.1 million. So it seems to, I don't know, my math isn't that great, but I think $331,000 is much less than $5 million. So I don't want to be cute here. Here's what I would just recommend and suggest to you, that especially in light of this coronavirus situation and people's need for health care, that you reconsider bringing these health units back and making sure that your employees have access to health care. That would be my suggestion to you. One more question on the public hearings. I think it's been asked by my colleagues. I just want to echo that. I think it's unfortunate that you don't have public hearings for these rulemakings, because not everybody is sophisticated enough to either write their thoughts out or have the money to hire a lawyer and so forth. And you probably could get a lot of insight by actually hearing from real people, especially workers, which gets me to another question, which is, let's see, the rule on the blocking charge policy, which pauses union elections when a party is charged with committing an unfair labor practice until the charge is resolved. So, in situations where there is an election to decertify the union, this policy is critical to prevent employers from intimidating employees into voting against the union. I'm sure you know that. So, you overhauled the policy. The board presented data that it claimed to show that the policy was created great delays in elections after a blocking charge was filed. Yet the Bloomberg Law reported December 5th, 2019, and I'm quoting them, "Review of the data supporting the rulemaking found dozens of cases in which the board overstated the length of delays attributable to blocking charges over the last 3 years, overshooting the mark in one instance by more than 12 years and another by 5 years. The dissent from the proposed rule also pointed out these errors." So again, this is, I don't understand this, but I guess is it correct that, or is it, yeah, correct is the word, that you did not correct the errors before issuing the notice of the proposed rulemaking? There was nothing changed or corrected?
We use the agency data. Member McFerrin, in her dissent, actually had her folks go through the data case by case, and apparently found some deviating circumstances. But we did use agency data. I will say, on this issue, sometimes the best policy is not made with statistics. One person denied an election is, in our view, worth looking at the issue, and that's one of the reasons we're doing that.
Okay. Madam Chair, I just got a note to go back to my other committee, but I want to thank you, and I yield back.
Thank you very much.
Okay.
Thank you very, very much, and I apologize to you again for, okay, anyway. Mr. Ring, I'm delighted that you did not participate in the board's recent McDonald's case due to your former law firm's work on the company's response to the fight for 15 minimum wage advocacy. However, I am astonished once again that Mr. Emanuel found himself fit to participate despite a clear conflict of interest. Mr. Emanuel's former law firm, Littler Mendelson, was retained by McDonald's corporate effort to set up a hotline for franchisees with Fight for 15 concerns. Today, you can still dial 855 McD Laws, and you are greeted with, "You have reached," it's what we have here, "You have reached the McD Laws hotline provided by Littler Mendelson, and are then provided the direct contact information of 3 attorneys ready to provide legal advice. This is pretty extraordinary. How, this is staggering in terms of conflict of interest here with the agency. How can we trust the NLRB under your leadership when it has been proven to be ineffective at stopping conflicts of interest? I have this document right here that lays this out. And McD Laws is 855-623-5297. This is, how do we trust what you're doing?
Well, let me answer that. First of all, I did not participate in the McDonald's case because, not because of any recusal issue, but rather because of our normal panel rotation. So that's the only reason I didn't participate.
So having worked for this law firm, you would have participated.
If
you don't see the conflict of interest?
Oh, no, I see a perception that you're raising, but because of that, and because we are committed to ethical standards and making sure that our recusals are in compliance with government ethics rules, this was run through our designated ethics officer.
I'm going to just stop you for a second, because it's the recusal process. Let me see if I get this right. The recusal process, which says that you shouldn't do this, is what guided you. But you personally didn't have a view that you're being engaged and involved with the law firm should not, I mean, I don't need to have somebody tell me that you can't do this, you can't do that. You have to have an underlying fundamental view as to what kind of a conflict of interest that we have. And we're under scrutiny all of the time for conflict of interest here. And so designate, but I don't understand why you don't think that it's a conflict of interest. And thereby, I guess you answer my question, is that Mr. Emanuel, why should he recuse himself from this process as well? Do I have this right?
Yeah, well, let me say this. We're labor lawyers. We know labor law.
Yes.
And we rely on experts on government ethics to guide us on what the rules are. Mm-hmm. And that's really what we have to do. And that's what we're expected to do. And that's what the government ethics rules tell us to do. That's one of the reasons we embarked on this very comprehensive review in our ethics report to make sure that we were in full compliance. And when something like this comes up, our ethics officer does a thorough analysis of the conflict, potential conflict and appearance issues, and based on that, provides a recommendation that we follow. I mean, that's I mean, the rules. You can change the government ethic rules if you want to, but
No,
I mean that we're bound by those, and we follow them.
Yeah, but no, you didn't. Not in the case of Mr. Emanuel and Highbrand. You had an agency that told you there was a conflict of interest, and then you proceeded to move forward and to say that he could participate, that he could insist on participating. Well, and, you know, you can't have it both ways. You just cannot have it both ways, which is what you're trying to do here. You don't listen to the Office of Ethics, then you say that you're following their guidelines, and you are not. You are rife with conflict of interest in this agency, and with that...
Thank you, Madam Chairman. Chairman Ring, I appreciate you being here today. Being from Washington State, obviously the coronavirus is of top of mind, just about any issue we're working on. And I have about 1,500 franchise businesses in my district, and I appreciate the work that you all are doing to give clear joint employer rules, including the rule you issued in February. With the recent outbreak of the novel coronavirus in my district, in my state, what does this new joint employer rule do to provide any clarity for employees that are looking to encourage in responsible policies with their franchises and contractors, like paid sick leave during the outbreak?
Well, I think what our rule does is it does provide clarity and some certainty about who is the employee's employer. And instead of employees looking to an employer that ultimately would not be their legal employer and not legally responsible, they can hold their employer, and their employer knows that they're responsible, and the direct employer, the employer that actually has control over the employee's essential terms and conditions, will be the employer that takes the action. So I think the major benefit to our joint employer rule, besides restoring it to its traditional test, is that we provide greater clarity and predictability and certainty, and I think of in a way that is a benefit to workers, to unions, and to employers.
So there's not really any, I understand in terms of legal liability, the clarity it has created, and I think has been welcomed just because nobody wants to operate in the uncertain environment. That's been a huge issue amongst small businesses in my district. So we do appreciate that predictability. I think more in my mind is there any kind of support mechanisms or guidance or basically, yeah, or is it just kind of, have you all put any guidance out with regard to how people can support their franchisees and the folks that are part of their, for lack of a better term, co-op?
Well, I think our rule does provide with definitions and I think greater depth and broader clarity, some the lines between employers. We have not we did not and have not put out anything that I think kind of does what you're talking about, where gives guidance on kind of responsibility in the context of this health situation we have now. Although I would say, I go back to my first answer, which is I do think having those clear lines and understandings of who's responsible and who's not is critical, particularly in a situation like this.
Thank you. So as public events continue to be canceled due to recent outbreak events in my state, they're closing venues, and a lot of the discussion is around how do we continue to support hourly workers or those who are affected directly by government mandated closures, people generally at the lower end of the income spectrum. Is the NLRB doing anything to ensure employees who may be impacted by these cancellations are protected?
We don't. The NLRB doesn't really have any statutory authority over that type of thing. I think that's probably the Department of Labor. But I will say there are obligations under our statute with respect to bargaining over layoffs if there are unionized employers
For example, like food service workers who are not going to be working a venue at a major sporting event.
Right.
So I do foresee this coming. I mean, it may not be the immediate, but in terms of the secondary, maybe even tertiary impacts, yes. I do see this coming. Oh, sorry, Madam Chair. Oh no, I still have a couple. I thought you were gabbling. I do expect this to be something that I think is going to touch all areas of our economy, whether it should or not. Right.
Yes.
My expectation is it'll be on your desk.
Well, I will say, I think our act does provide those type of protections of, in a particularly in a unionized context for those that where there might be a layoff or other kind of job disruption.
Thank you. Yield back.
If I might, because you've asked a very pertinent question. What in essence is the case here is that those folks that the venue is canceled, if an employer shuts down, only 27% of people who work in the private sector today have paid sick days. There are not even one paid sick day. So honestly, you've exonerated the franchisee, the local, and the parent organization, I might add, from having any, I don't want to even say legal responsibility, having a moral responsibility. These are people who serve all of us. Nobody is taking away your sick days, my sick days, anybody else, but those folks who are washing dishes, who are serving meals, who are distributing food at a venue, etc. They're on their own. They are on their own. And what we are trying to do here is to say that businesses that have 50 or fewer employees, that they provide the 14 paid sick days to people who, through no fault of their own, are out of work. And they have children, and they have expenses every single day, and they work hard. But not my problem, big corporation. I don't have to do it. Franchisee, I don't. I'm not legally responsible. More than likely, these folks have not been able to organize or to unionize. And they can't deal with collective bargaining. When the reality of what is being done is placed in the context of people's lives, it describes what a lack of understanding we have about workers in this country and how hard they work every day and what our obligations and moral responsibilities are when a situation that they cannot control, cannot do anything about, is foisted upon them. Then I believe it is government's responsibility to step in and do something about it. And that is my hope, is that what we are going to do over these next several days is to make sure that these workers get paid sick days, and that we will deal with the appropriate authorization or the appropriation of dollars to do it, because you would exonerate businesses from doing anything about that. Mr. Robb, your testimony paints a rosy picture of what it is like to work at the NLRB under your leadership. Unfortunately for your employees, the data tells a different picture. Since 2016, employee satisfaction on the Federal Employee Viewpoint Survey for the NLRB has declined by a stunning 30% for agencies of your size. The decline since 2016 has been just 2%. The board ranks second to last in satisfaction overall, just ahead of the Department of Education. Are you at all concerned or alarmed about what these dismal statistics say about the management of the effort here, your organization?
I'm certainly concerned about it. I would much prefer that the survey yielded better results for the NLRB. We're trying to do more in terms of communication with employees and giving more understanding both to managers and to the employees with respect to why things are being done. So yes, I'm concerned about it.
Okay. And again, under your leadership, a concern has got to really translate into action, because under your leadership, you eliminated the health unit for your employees at the D.C. headquarters, as I understand it. And I am told you were concerned about the cost of maintaining it, which quite frankly flies in the face. If it weren't so sad, it might be laughable, because you are not spending the agency's money. The appropriation, which on a bipartisan basis we have questioned you on, but you're spending money on resource-intensive rulemaking efforts. You are you've cut back your spending, but you eliminated the health unit for your employees at the DC headquarters. Why have you not reinstituted the health unit for the headquarters staff?
As you know, the health unit was eliminated because of budget concerns in the 2018 year. And that was done pursuant to a task force that included the union's representatives at the agency and a variety of managers. It was done not by me. It was done by my predecessor. That report indicated that there was $16 million that would needed to be saved in order to make sure that there were no layoffs or furloughs of agency employees if the budget funding came in at the appropriation level that was requested by OMB. So that was ultimately implemented because of the recommendation to me, which I pushed on to the board, that unless we started to implement those cuts by January of 2018, we would have been in a serious situation where we may have been required to furlough people, which is something that nobody wanted and I didn't want. So once it was eliminated, then the question became a matter of how effective it was vis-a-vis other things that we needed. There was a lot of infrastructure in our computer systems that needed to be updated. As you know, because we provided the materials to the committee, the reason we didn't spend the $5.1 million for 2019 was because a series of contracts that were either disallowed.
Let me just stop you for a second, and I hear you, and I want to hear the explanation. But you traded off a health unit for your employees to computer technology. You also you let resources that we provided, bipartisan basis. We challenged you guys on this. You provided, lapsed $3 million 2018, $5.7 million in 2019. Well, 5.1, you could have dealt with this if you didn't just let $5.7 million lapse. There is no explanation. Health unit, today's cost for health for people in this country? My God, how can that be a trade-off? And we've provided you with allocations. And my time is... stunned. I mean, that's, you know, look, budgets are documents that have values. It's not about, it's people and what the repercussions are. The health unit and not would you, let me just ask you this. Would you reinstitute the health unit? Will you reinstitute the health unit?
The health unit for next year would be under consideration. I heard a request here that we reconsider whether we would institute it or not, and we certainly will consider that. It's been brought up in negotiations with the unions, so it will be under consideration. Whether when we look at the budget, it's the right thing to do or not is something that I can't answer now.
But morally speaking, you as an individual, what do you think about reinstituting a health unit for employees as some sort of a priority that makes sense? I mean, I've managed people. I think about my staff, what I would do, what I would trade off, what are the, you know, this is, we all have these considerations. What do you believe we ought to do with this?
What do I believe?
What do you believe we should do about reinstituting a health unit? Yes or no? Do you,
At this point, I didn't see the justification for reinstituting the health unit.
okay, fine, thank you. You answered my question. Let me, whoa, that's something. Mr. Ring, again, at the American Bar Association's recent law conference, you were asked whether recent board decisions advance workers' rights. It was reported, and you look at what's reported and you ask a question. It was reported that you replied, quote, "Are you suggesting that our job is to advance employees' rights?" End quote. I remind you of what I said at the outset in my remarks. Section 1 of the National Labor Relations Act states that it is the policy of the United States to encourage the practice and procedure of collective bargaining and to protect workers' rights, to unionize for the purpose of collective bargaining. Under your chairmanship, every major decision that the board has issued, overturning precedent, and every rulemaking is antithetical to this policy. If you disagree, can you give me an example?
Sure. First of all, I'm not familiar
With your quote?
Yeah, and certainly
I get that.
Okay,
That happens to us
certainly
all the time.
Part of certainly I would agree with you that one of the purposes of the act is to protect employee rights. There's no question about that. I think what I did say, and I do believe, is that this board is not here to put their finger on the scale or the thumb on the scale for any particular group, employees, unions, or employers, but rather the board is to fairly and impartially enforce the act, and I think that is what we are supposed to do.
It says to encourage the practice and procedure of collective bargaining and to protect workers' rights to unionize for the purpose of collective bargaining. It is not to be a neutral umpire, which is what was said, I guess, what a senator said. You're not a neutral umpire in this regard. Well, I understand you have to balance things, but this is the stated purpose of your agency.
I will have to disagree with you because you're taking one quote out of the.
No, I forget the quote.
Yeah, but it also says that it's
quote.
for those who choose to be unionized or choose to organize or those who choose not to. So we are balancing, and we are supposed to fairly and impartially not look at the cases and or the issues that come before us and decide those based on the facts fairly and impartially. But not putting the finger on a scale for.
But you have apparently with some of the rulemaking you have made, you've put your thumb on the scale for very big corporate interests, like McDonald's, like the shuttle example, etc. Here, which people are forced to sign non-compete clauses and entrepreneurial opportunity. They have no entrepreneurial opportunity, but we put our thumb on the scale here to put them in a category where they're in limbo. You know, there is a new economy out there. And what we have done is to say we contract, we subcontract, and we don't have any responsibility here at the corporate level. And the folks there, well, it's up to them. If they want to do it, fine. If they don't, we don't have any. So people are just hanging out there without any opportunity for the ability to organize, to get health care rights, to deal with unionizing, benefits, or anything, because we've said adios. Isn't your mandate in terms of the new current economy, a gig economy, whatever you want to call it, responsible then for what's happening to workers and workers' rights? And not put your thumb on the scale for corporate interests?
Well, I think if you look at what we've done over the last year or two, we've restored the joint employer standard to what it had been. We restored the independent contractor standard to what it had been.
Well, joint employer changed. It changed.
Well, it's really actually is back to essentially what it
Right.
was before.
And
Better clarity.
focused on a new time and a new place because we are in a new economy. We have set up different efforts, and there's this move to subcontract, to contract out, to do that, to label people as independent contractors. So, in fact, no benefits need to be paid. That is, that's not my view. It is what all of the data and all of the literature tells us about what is going on. And I have to interrupt because my colleague has come in and out because he's doing business in a variety of committees, I'm sure.
Thank you very much, and thank you very much, gentlemen, for being here today. First of all, with regard to the joint employer, I personally, for the 2,000 franchise businesses that operate in my district, the vast majority of them very small businesses, some of whom I'm sure will be hit by the, the coronavirus economic disruption. I want to thank you for returning it to the joint employer standard from before. The previous standard made sense. I mean, the bottom line is these are not jointly employed. I know these franchisees. I know them personally. So thanks for bringing common sense to that. Let me and just to clarify, I think I was here when you testified that with regard to Mr. Emanuel and the question of ethics involvement in the judgments, the board's designated agency ethics official did clear him on his participation in that case, right?
Well, so this is an important point. I'm glad you raised this. He was cleared. There was no ethical concerns raised with his participation in the High-Brand case.
The rulemaking.
Right.
No, this is the joint employer case. The joint employer case.
I know that, but
Okay.
for the rulemaking on joint employer, not in the prior case. Anyway, go ahead.
Well, I think Dr. Harris, what you were asking was about the cleared for the High-Brand case.
That's correct.
Okay.
Yes.
So he was cleared to work on that case, sit and hear that case. After the fact, there were concerns raised about how that case had been adjudicated. Frankly, they were unprecedented concerns about how that case had been adjudicated. And based on that, and concerns, the designated ethics officer retroactively said he should have recused himself from the case. Frankly, that is why we embarked on our ethics report. Was when I came to the agency, and this all happened before I got there. I had a number of concerns. I hear them, and I share your concerns about the perception of the agency when those type of things happen, because I think the average worker says, "What in the world is going on?" Where you have people that are cleared to sit on a case, decide a case, and then after the fact, they're now called unethical because they did that. Right. So that's what we tried to clarify in our ethics report, and we wanted to make sure that we had transparency and a clear understanding of what the rules of the road are on ethics. You weren't here before when I said it. We are labor lawyers. We are not ethics lawyers. There is a whole body of law in government ethics, and we tapped into that to understand it, to make sure we had a clear understanding of what the rules are. And, one of the things that we learned, whether we like it or not, is that a board member has the ultimate right to decide whether or not they will sit on a case. That is, you can change the law if you want to, but that's the law. And what we did with our ethics report was make sure we had a process so that we could manage that in the future, and so that people would have confidence in the way we managed it in the future.
Sure. No. Thank you very much. Now, with regards to the lapses in funding and allocations, of the $5.1 million unobligated balance, it looks at all but $1.2 million as a result of unforeseen contracting issues. So isn't it true that close to half of the unobligated balance is a result of a GSA decision preventing a contractor from accepting a contract offer because of an unrelated issue with an underlying agreement with the GSA?
But that accounts for most of our surplus, yes.
Right, and so of course that's not anything you have control over. And are any of the functions of the board impaired by the failure to spend, these taxpayer dollars?
No, and in fact, I think while we did spend less than expected. Our shortfall did not affect our overall performance or ability to accomplish the mission. We were able to add personnel where they needed. We were able to spend resources on things like IT infrastructure, which is critical. We're way behind on that, as well as training across the agency, while looking for more effective ways to accomplish the mission.
Sure, thank you. And just finally, I know that there's criticisms of partisanship on the board, but look, the law says that the president appoints people, and I will tell you that I think there was partisanship when the joint employer standard was changed, and it was pretty clear. It was a pretty clear bias. Look, if Congress doesn't want that, then constitute the board in some different way. But the fact of the matter is that elections have consequences. The president won the election. I know some people still deny it. The president won the election and has the right to appoint people to the board who may have a different philosophy from the previous board. I yield back, Madam Chair.
Thank you very much. And I would just like to make a point about the NLRB member. It is important to note that the NLRB tried to change the joint employer standard first through adjudication in 2017. But the NLRB member, William Emanuel, had committed an ethics violation by participating because he had a conflict of interest. So you first went the route of adjudication. So then, given that they said that he had a conflict of interest, what the rulemaking proceeding and doing that, moving to that, where then he was allowed then to be a part of the rulemaking. So it was an effort to circumvent the ethics rules that would prevent him from participating in other cases raising this issue. So it was a way to get around the adjudication process, because that's what we used to do in the past, but you can do rulemaking behind closed doors. So I love to save taxpayers' money, contrary to what some of my colleagues believe, but if there are contracts that come up that we can't handle or we can't do something about, then that says something about management and at the least about how the agency is managing itself, because we don't have any other agencies that have lapsed 2 years in a row or 3 years in a row, and where we had to have a bipartisan deliberation and passed in a law that says, you can't do this, friends, you can't do it. And we asked you to fill these capacities and these things by the end of 2019, and we are not there yet. Look, there are probably more questions. I don't know if my colleague has any more questions. I think we have some serious issues here. I go back to the mission statement. I also do want to mention Super Shuttle. Super Shuttle. The board permitted its employees to be misclassified as independent contractors on the grounds of entrepreneurial opportunity, okay? Despite the fact that the drivers, they were forced to sign non-compete clauses, undermining any entrepreneurial opportunity. One has to conclude that this is about denying benefits. Now, that's where I conclude. I would just, and a final comment before we bring the hearing to a close. Look, yes, people do have different philosophies. Elections have consequences. I don't deny that the president is president of the United States. I have a view of who I'd like to see as president next time around. I believe in the system. I believe in democracy and government, and that's the way we proceed. But I will tell you that stay true to your mission. I think we have so much evidence that allowing for workers to have their rights protected and to be able to organize and collectively bargain, that so far you've been in the business of eroding them, whether or not there's drivers for Super Shuttle, or it's about the graduate students who are doing major, major work for the academic community, of being denied their rights. I know my colleagues support the new ruling, but as my colleague, Congresswoman Herrera Butler said, those folks today who are going to be out of work, not through any fault of their own, but because of a coronavirus, business may be shut down. We've got the Center for Disease Control saying, stay home, stay home. But they don't have sick days. And the likelihood under the system that you have crafted and constructed, they will not have paid sick days. And unfortunately, we, and I say we as the Congress, is going to address that issue in an economic package for American families, for American workers, in trying to recognize and understand the role that they play in our society. None of us, Congressman Harris and myself, if we were told to go home for 2 weeks, 3 weeks, 5 weeks, whatever it is, you bet we would continue to get a salary and we would get our sick benefits paid for. If it's good enough for members of Congress, then it's good enough for the American worker. This hearing is concluded.